We can stop Trump's judicial appointments with a constitutional strategy that John Roberts laid out back in the 1980s, but has not been tried before in America. Check this out. Leave your comments, ding the bell, share it with your friends, and subscribe to our channel. One of the things that I found absolutely fascinating this morning, I was just, poking around the internet and found this story that was published. Matthew Chapman wrote it. It's over at rawstory.com. The headline is, Dems can use this constitutional trick to stop Trump's judges from dismantling Biden's agenda. And you go, oh, really? How do you do that? After all, Trump put basically a third of all the federal judges on the federal judiciary. Trump appointed because for most of Obama's presidency, Mitch McConnell refused to let his judicial nominees, including Merrick Garland for Supreme Court, go through, which was a crime, in my opinion. But here we are. So what do you do? Well, I wrote about this in my book. In fact, this is why I wrote this book, The Hidden History of the Supreme Court and the Betrayal of America. The newest one that's out literally this week is The Hidden History of Monopoly, How Big Business Destroyed the American Dream. Ralph Nader wrote a brilliant foreword for it. And that's a fascinating take, and I've been doing a lot of media on that. But the Supreme Court book, the last chapter in it, kind of builds up to this. The last chapter in the book is about how John Roberts, when he was working for Ronald Reagan in the Reagan Justice Department in the 1980s, he had been asked by Reagan's people to figure out a way to have the federal government ignore the two Supreme Court rulings. How can we get around these two Supreme Court rulings? One was Brown versus Board of Education, 1954. It's illegal to have segregated schools. And the second was Roe v. Wade, 1973. It's illegal to ban abortion. States can no longer block women from having abortions. And, Reagan's people asked this young lawyer, John Roberts, how do you get around this? I mean, these are Supreme Court decisions. And Roberts wrote this a nearly 30-page memo, which I found, and I don't think anybody had ever even known that this memo existed. I mean, it took me the better part of a year to find this thing and kind of ferret out and dig it out of the bowels of the Justice Department. And in this memo, John Roberts says, well, Article 3, Section 2 of the Constitution says, and it does say, that Congress can create exceptions to what the Supreme Court can rule on. In other words, Congress can pass a law, and in that law, they can say the Supreme Court may not rule on this. So if Congress wants to ban money in politics, all they have to do is pass a law banning money in politics and then say this law may not be reviewed by the Supreme Court. It's right there in the Constitution. Now, Roberts recommended that to Reagan, although he said be very careful, because if you use this, then the Democrats will use this, and you're going to weaken the Supreme Court by doing this. So be very careful. This is in emergency break glass. And Reagan ultimately decided not to do that. No president has ever done, well, actually two presidents have done this. Andrew Jackson did this, ignored the Supreme Court in two cases, for the Second National Bank of America and the Trail of Tears. And Abraham Lincoln ignored the Dred Scott case and said, well, that's a terrible thing for Mr. Scott, but, we're going to go ahead and pretend that case was not ruled on that way by the Supreme Court. But it wasn't Congress in either case overruling the Supreme Court. What John Roberts was suggesting is that Congress can overrule the Supreme Court. And I lay it all out in The Hidden History of the Supreme Court and the Betrayal of America. And so now this legal scholar, this guy, Christopher Sprigman, writing for the New Republic, says, Article 3 of the Constitution gives Congress substantial power to strip federal courts' jurisdiction, a power that can be employed to rein in politicized courts and even to override judicial decisions. And he's right. And John Roberts is right. It's just never been done in any kind of consequential way. And I think it should be done. I really think it should be done. And because we need to reverse Buckley versus Vallejo and First National Bank versus Bellotti, the 1976, 1978 decisions that said that when billionaires or big corporations want to own a politician or even an entire political party, that's not corruption, that's free speech. Those decisions need to be reversed. That is the cancer at the core of all the problems we are facing, including the problem of Donald Trump. If it wasn't for billionaire money in politics, Trump would not be in office. And, we did a lot about this during the Jerry Ford administration, after the Nixon bribery scandals, and in the Jimmy Carter administration. I mean, we passed a bunch of laws to get money out of politics. And then along came the Supreme Court and blew them up. So, I'm hopeful, now that you've got actual, lawyers, actual law professors and legal scholars talking about this seriously and taking this seriously, I think that, there's some real potential